This is the site of the first gold discovery in Oregon. In its day, millions of dollars worth of gold came out of this little creek alone. The Illinois River itself was loaded with placer gold. Over the years, hundreds, if not thousands, of prospectors and miners worked this area alone. Almost every rock in sight has been moved by miners. All of these trees have grown back since the heyday of mining occurred in this area in about 1850 to 1860s. This shows that even the tremendous amount of mining doesn't necessarily leave a permanent scar. Lode gold is your typical underground type deposit. The gold is still locked up in the rock that it formed in. So typically you would mine that by going underground, digging tunnels, sinking shafts, things of that nature. Placer mining, which was the most popular method of mining in Josephine County, is any kind of gold deposit other than a lode. So it basically means if a lode deposit erodes due to weathering, landslides, earthquakes, glaciers, anything like that, that lode deposit, that if it's exposed on the surface, when it erodes away, as soon as the gold moves away from the vein, it is considered placer. And over eons of time, that gold, because it's so heavy, will slowly work its way down the side of the mountain, and eventually it will get into a stream. Suction dredging has been shown to be the most economically effective method of mining those kinds of deposits, and also the most environmentally friendly method of mining those deposits. The dredge adds absolutely nothing to the water that wasn't already in the water. No chemicals are used, there's no special processing, we're not grinding the ore up into dust, we're not doing anything, we're just sucking the material up, running it through a gravity sluice box, and the gold settles out just by its weight alone, and the rest of the material basically falls back into the waterway from where it came from. Starting in the 1990s, a local environmental group in this area filed a lawsuit against the Siskiyou National Forest for failure to require a plan of operations for suction dredge operations. The Forest Service mining regulations spells out when a plan of operations is required, and it's basically only required if you're building a road, cutting trees, or using heavy earth-moving equipment such as a bulldozer or a backhoe. The other time a plan of operations could be required is if you are likely to cause a significant surface disturbance. Because the suction dredge operates solely in the water, the disturbance is subsurface, it's underwater, and even more importantly, it's not significant. All it takes is one winter high water flow event, and it will naturally erase all sign that the suction dredging ever took place. This day and age, if you submit a plan of operations for approval, the Forest Service and the Bureau of Land Management claim that that triggers the National Environmental Protection Act, or NEPA. NEPA requires, before the government agencies can make any decision whatsoever, they must first do either an environmental analysis or a full-blown environmental impact statement. Either one of these can take years to do. The Forest Service allowed the environmental organization to basically say almost anything they wanted to in court, and they didn't dispute any of it. It was all based on the 1994 Northwest Spotted Owl Forest Plan, where basically everybody thinks that was a timber management plan, and it was. It's books this thick, but on half of one page it dealt with mining. And what it basically said, they had this, well, it's called Minerals Management 1, or MM1, and it basically said any mining operation within a riparian reserve, which is basically anywhere near water, will be required to have an approved plan of operations, a reclamation plan, and a bond. Well, when the Forest Service lost the lawsuit against them, they didn't even bother to appeal it. Instead, they came to the May meeting in 2000 of the Waldo Mining District and told area miners that from now on we would need plans of operation before we could run a suction dredge. Knowing full well that they had not approved a single plan of operations in the Siskiyou National Forest for over 10 years. The local environmental organization that started all of this filed a third lawsuit in, I believe it was February of 2003. The suit took over 6 years, it went through Magistrate Court, U.S. District Court, and then it was appealed to the U.S. Ninth Circuit. It was held on a hearing on February, I believe, 2nd, 2008, and the decision just came out this year in, I believe it was March of 2009, and the decision was that MM1, or Minerals Management 1 of the Northwest Forest Plan, could not be used to require plans of operation for mining activities unless those activities would need a plan of operations under the Forest Service mining regulations anyway. So where we stand today is thousands and thousands of dollars have been spent in legal fees. All it would have taken in the earliest suits was for the Forest Service to have raised their hand in court and said, but Your Honor, on page 1 of the Northwest Forest Plan, it plainly states that nothing in the Northwest Forest Plan supersedes existing law or regulation or gives the agency authority they don't already have. Nobody brought that up, and it took almost 10 years to fight this.